Hello, welcome back. Miss Bragg? Yeah, there we go. If I may, just one point of clarification, which I wrote down and then forgot to ask for the end of the last session. Mr. Boy, you referred to a signed version of the 106 agreement, the unilateral undertaking. The version that I have isn't yet signed, and I just wanted to just double check that was the position.
I should perhaps have said agreed rather than signed in that case. Okay,
I just wanted to clarify whether things had moved on.
No, that's a slip of my terminology.
No, that's fine. That's fine. Thank you for that clarification. So in going through the timetable at the minute, Mr. Boyle, it's your witness for, have we got? Oh yeah, can see Mrs. Wright. She joining us? Welcome.
There we are. Good. Madam, I think all that we'll need for Mrs. Wright's evidence, forgive me, is her own proof, Mr. Miller's proof, Mr. Cook's proof, and the MPPF. We might also want to look at the statements of common ground for planning and housing land supply, but we may not need to actually physically turn those up.
Thank you.
Thank you, Madam. Now, Madam, Mrs. Wright has got a summary at the end. In my version, it's bound into the back of her proof, which is relatively short. I'm entirely in your hands as whether you'd like her to read that out for the benefit of third parties. Otherwise, I propose to introduce her and then orally take her through some of the outstanding matters to emphasize and clarify.
I don't think we have any third parties with us today.
Excellent. Well, in that case, if you're content, I'll just crash on with the...
Can I just double check that? I'm pretty sure that we don't. I've got no list on the attendees, and I've just got council and your own representative. So I think I'm fairly safe in proceeding that we don't need to necessarily read all of that out.
If I may just interrupt that briefly, that's correct. I don't think there are any kind of participants on the call, but I do understand that this is being live streamed as well. So I'm not sure if anyone is watching sort of externally as opposed to being part of this Zoom call.
Yeah, thank you for that reminder. I still don't think it's necessary for the whole of the proof to be read out, and no doubt Mr. Boyle will take us to the salient points he wishes to highlight.
Thank you very much, Madam. So, Mrs. Wright, if I take you to the beginning of your proof, please. And there I discovered you're Aaron Wright, is that correct?
That's correct.
And you're a chartered member of the Royal Town Planning Institute. You hold a Bachelor of Science Honours degree in Environmental Management, University of Lancaster, and a Master's degree in Town and Country Planning from the University of Reading. You've practiced as town planning in public and private sector for over 19 years, is that correct?
That's correct.
You tell us you're an Associate Director of Turley. You've been such since October 2018. Prior to that, you're planning manager at David Barrett Wilson Homes. Brief experience working for local authorities, Havant and East Hampshire District for approximately 12 years. Is that correct?
It is.
And you say you're familiar with the site, having provided advice on it since 2020. You were the planning consultant overseeing negotiations regarding the application. You're familiar with the related disciplines as we see there set out. Thank you very much. And we see the statement of truth at paragraph 1.5. Can I take you through a series of matters, please, without reference to reading parts of your text, but with reference to the proof and its structure? So first of all, can we see that you identify at section 2 the reasons for refusal? And we know that the second reason for refusal has now fallen away, subject to the agreed section 106 obligation and conditions.
That's correct.
And just on that second point, the conditions between the parties are agreed you can assist me in the appendix of the Statement of Common Ground, CD 4.3, being derived from the conditions proposed at the application stage when officers were recommending approval for this scheme.
Yes, there was discussion with the case officer ahead of committee regarding conditions, and they were agreed between the parties, and they are the same as those in the Statement of Common Ground.
Thank you very much indeed. Your next section deals with the site and its surroundings, which again, I don't ask you to read any part of, but just to pick up, if I may, at your page 8, the Map 1 facilities audit.
Yes.
And my version is just, I think perhaps just the way it's printed is rather faint, but we can see that there's the location of the site and then distance measured in circumferences. And you set out in the text opposite the services and facilities available within those areas, within those distances, to residents on the site. And if we turn the page to map 2, you do a similar exercise in terms of the network for public transport, cycling and walking.
Yes, these diagrams have been taken from the design annexer statement.
Thank you very much. And is there within that any dispute as to the sustainability credentials of the site in terms of access to services and facilities, i.e. its location for suitable residential development?
No, there's not.
Thank you very much indeed. Thank you. Let's just take that as read then and move on to section 4, planning history and context. Now, we'll hear in due course perhaps a little more from Mr. Cook on this, but can you just briefly outline the process that lies behind the application now before the inspector, and in particular the consideration through the neighbourhood plan process?
Yes, so the site was assessed in the emerging, the Overton neighbourhood plan. So the site was referenced as Site K. It went through a full consultation process. There was a number of documents that were undertaken and prepared, including a sustainability assessment. And the site was looked at by the Overton neighbourhood plan and was put forward as a reserve housing site. The draft local plan went to an independent inspector for review, and the site was removed, but that was due to the risks, whether there was any need for any additional sites rather than the principle or the sustainability or acceptance of the site.
Thank you very much. And if we just turn to page 14 of your evidence, do we there see the draft neighbourhood plan reserve housing site, Site K?
Yes.
And there should also be, I hope, a notation J, which is, as we know, it's 7 acres.
It is. So 7 acres is has just been built out by the appellant.
Thank you very much. Now, there you can find it in a number of different places, but if you have Mr. Cook's evidence to hand, his figure 15 is the parameters plan before the inspector.
Yes.
You have that. And can we, if we just compare the two, one to the other, can we there see it's marked in blue for map 4, but in red for figure 15, the parameters plan, the boundary of the site in question.
Yes.
And then within it, marked in red on map 4, but in buff colour, the area of built development.
That's correct.
Within the wider site. And just help me with the, again, I will come back to it with Mr. Cook, but with the broad rationale for the location of built development within the site, as opposed to the green infrastructure, which is proposed for the rest.
Yes, the site was put as part of the Overton neighbourhood plan. It was felt after looking at the constraints and opportunities of the site, looking at the existing trees around the boundaries of the site, the sunken lanes, looking at the existing built development, that was the most appropriate location for the development, and also the topography of the site lends itself to having the built development in those locations.
Thank you very much. Now, Mr. Miller not unreasonably indicates that you can't give much weight to a draft allocation, which has now subsequently been overtaken by the adopted plan, the made plan. But in terms of the indication of the suitability of the site in principle, in terms of its merits as opposed to its status, what do you say this process tells the inspector?
I think it tells the inspector that the site was positively encouraged. They looked at the environmental, the landscaping, the economic benefits of the scheme. The Overton Sustainability Appraisal Report confirms that the site would have a positive effect on the viability and vitality of the village, including supporting the local shops and amenities and the public transport network. And it was also voted upon by residents, although it didn't make it through to the made neighbourhood plan. It certainly went through scrutiny and was considered an acceptable location for development.
Thank you. And what does it indicate in terms of the acceptability or unacceptability of landscape impact of developing in the location proposed?
Yes, again, I think with adequate landscape mitigation, also public open space, and having the built form in the best location in terms of topography of the site, that development could be achieved on this scheme.
Now, we know, and you've indicated it wasn't a merits reason, we know that didn't go to allocation. Nonetheless, an application was submitted. What was the approach of officers in the context of the application coming to them and then their recommendation to members?
Yes, we undertook pre-application discussions with Basingstoke District Council ahead of submission of the application. Their comments were very positive and supportive of the scheme. We then submitted the planning application. We received no objection on highways, on the environmental impacts, biodiversity. We had no impacts on environmental health, and we had a recommendation from the case officer to support the scheme, and it was taken to the planning committee with officer support.
Thank you very much indeed. We know that the authority throughout this period, and indeed now, are unable to demonstrate a 5-year housing land supply, and as a result, paragraph 11D is engaged, and within that 11D, little 2 is acknowledged to be engaged because there's no A and B objection taken. Yeah. The consequence of that has been explored both by you and Mr. Miller for the SS policies and them being out of date. And with me a moment ago, you'll hear he also recognised that apply to the EMP policy and LBE1. Question then goes to matters of weight. And just to help the inspector, as far as the SS policies, what is the agreed position on the weight to be given to breach of those?
I'm just going to correct page in my statement. So it is moderate weight to policies SS1, SS4, SS5 and SS6 in breach of policy. Thank
you very much. And in relation to EM1 and LBE1, the weight to be given to those, notwithstanding the fact that they're caught by paragraph 11D in the footnote.
Full weight.
Thank you very much. Now, in the light of that, when the reason for refusal, contrary to officer's recommendation, the reason for refusal came out, and I'm only concerning myself with the first reason, the operative reason, to what extent did it seek to object to the scheme by a reference to breach of the SS policies?
It doesn't. It does not reference those policies within the reasons for refusal.
Thank you very much. Can I then turn, with that in mind, to your section 6? There you set out in brief the nature of the policies through the development plan, noting, of course, at your paragraph 6.4, the development plan itself was adopted back in May 16 and had been in gestation since 2007. And over the page at paragraph 6.8, the SS1 assessment of development needs of 15,300, that's an at least figure, is itself a housing assessment of need now out of date by reference to the MPPF.
Yes.
Yeah? Thank you very much. You then set out the other SS policies in brief. And if I go on, if I may just come back to the point in a moment, to your section 7 and table that I find at 724.
Yeah.
these are the non-cited policies, but just in terms of compliance with them, you first of all identified whether they're up to date or not up to date, and we see what's there written, and that doesn't appear to be in any way in dispute, and the weight to be given to them, ditto, not in dispute. In terms of conflict or non-conflict, SS1, you identify partial conflict. Just in simple terms, what arises by way of a partial conflict with SS1?
So policy SS1 is looking at the scale and distribution of new housing. Although the housing numbers are clearly out of date, it's still looking at putting housing in sustainable locations, and it's considered that Overton is one of the most sustainable locations in the district. So that was the reason for the partial conflict.
Thank you very much. SS4 and SS5, SS4 is to do with ensuring the supply of housing, and SS5 is the neighbourhood planning approach. You've identified no conflict. What are those policies seeking to do, and why is it that the scheme doesn't conflict with those aims?
So policy SS4 is looking at the scale and distribution of housing, and it requires a 5-year supply to be maintained over the planned period. At the moment, the council cannot demonstrate a 5-year housing land supply. So this scheme would actually provide the council with the housing numbers to ensure that they can start delivering the housing numbers that are required.
So when you say no conflict, is the scheme facilitating the achievement of SS4?
It is. It's ensuring that the council can provide the housing numbers to meet the housing numbers in their local plan. And again, policy SS5 seeks development in around defined settlement policy boundary. So the site is adjacent to the settlement policy boundary, and it confirms that Overton needs to achieve at least 150 homes. That's not a minimum requirement. So again, I feel that this scheme complies with that policy, and that it is providing the housing in and around the settlement policy boundary of Overton, and will help achieve at least 150 homes.
Thank you very much. SS6, then, you say there is a conflict, new housing in the countryside. And if we go back to your paragraph 614, and we could, if we wanted to go to the actual plan itself, we see SS6 is one of those, I call them the old-fashioned countryside restrictive policy, that is agriculture, forestry, essential needs, and so on, of which we are not one. Yeah,
that's correct.
And in those terms, the policy boundaries to which they relate, which are derived ultimately from the SS1 policy at your paragraph 6.9, are those policy boundaries up to date or out of date in the current context?
They're not, they're out of date.
Thank you very much indeed. You heard, I hope, the way in which Mr. Miller responded to my questions on this point. The inspector's first reason for refusal is not in play between us. That is, there's no allegation that the site is an unsuitable location for the provision of housing by virtue of being outside settlement boundaries in this location. Is that a matter with which you agree or disagree?
I agree. They haven't put an in-principle objection to the site. Thank
you very much indeed. Can we then go back to the matter which is an issue, which is the landscape and visual impacts? So reason 1 and the inspector's issue 2. And for this, please, for this, please, it's helpful to turn up the MPPF if you have it. I lost it now. And paragraph 174. You have that?
I do, yes.
Paragraph 174, and we see the distinction that I put to Mr. Miller between A and B, and the parties acknowledge that the site does not sit within a valued landscape for the purpose of paragraph 174A.
Yeah? That's correct. The site is not a valued landscape.
Thank you very much indeed. Now that, as we know, doesn't mean there's no value to it. It still has to be assessed, etc., etc. But what does it do to the weight that a planning decision maker gives to identified landscape and visual harm?
I think when it comes to decision making, you have to look at the different designations of sites. You have obviously a national park, AOMBs, valued landscapes, and in this instance, the site does not fall within any of these designations, and therefore it should be considered in terms of the weight to a decision.
Thank you very much. We know that at paragraph 175, there's a reference to the hierarchy, international, national, locally designated. Where does the landscape that the inspector is here concerned with, where does it fall in the hierarchy? Within it, above it, or below it?
I think it's below it.
Thank you. And again, what does that do to the weight to be accorded to landscape harm?
Again, it's, I think, weighing up the benefits of the scheme and the harm to the landscape. And this is not a valued landscape, and it's not within the hierarchy of any designation.
Thank you very much. Now, you would be familiar, no doubt, from cases you've been involved with, other decisions, etc. The reference to landscape impact being localized is a phrase often used. Yeah.
Yes.
In contrast to landscape impact being over an extensive area. What, again, in matters of weight, how does that play in terms of the weight to be given to landscape and visual impacts?
I think that if there is localized limited harm, then that has to be a consideration in terms of, again, the benefits of the scheme and the tilted balance when coming to the NPPF and 11.D.
Thank you very much. It wasn't a document I think I asked you to have to hand, but it might be useful just to go to Mr. Dudley's appendices, if you don't mind. And do you remember that his appendix 3, he's got the viewpoints that he draws to the inspector's attention?
I'm just getting that now. Sorry, which viewpoint was it?
It's his appendix 3. There's a map with viewpoints. Do you remember?
Yes, I got it now.
Got it. That's very helpful. Now, I won't obviously rehearse with you the points he and I went through in terms of how representative certain of these are for the receptor in question, or whether he's strayed into the field, for example, as opposed to the sunken lane. But just in terms of the location of them and the concept of localized impact, what comment do you wish to make in terms of the points that he's identified to take exception to within that concept?
Yes, I think if you, with the inspector, when she makes her site visit, will see that the site is screened from the sunken lanes by mature tree belts. There is very localized views into the site. And again, the area of outstanding attribute is over 1.3 kilometres from the site. And again, I think you've already discussed, Mr. Tipley, the point on the AOMB issue, but the site is very well screened, and again, it's very, very localized harm.
Thank you very much. And if one stands either in or immediately adjacent to the boundary of the site and looks at a green field and thinks of it as a housing estate, to what extent should be one surprised that there's going to be a difference in character before and after the event?
Yes, I think there is always an inevitable change from a greenfield to a housing scheme, but in this context, we do have the development in Pond Close, which is 1970s development. You can see their rear gardens, the paraphernalia in the gardens, also the 3-storey block of flats, which is into Pond Close. And so you see the site in the context of existing built development.
Thank you very much, Nid. And again, what does that do to the weight to be attributed to any such harm that might be identified?
Again, you have to take that into consideration and weigh the existing context in the fact that there is existing built development as you view the site.
Thank you. We know that under 11D(2) we have a tilted balance, as it's put. That means that permission should only be refused consistent with national policy if the harms, and it's now just recent refusal 1, are significantly in excess of the benefits. Yeah. Can I turn now to your section 8, please, in benefits? Do you have that?
I do, yes.
And you recall again with Mr. Miller, we went through a number of these. He started with significant for the provision of housing per se, market housing per se. He had started with limited for affordable housing, being policy compliant, but he recognised there was no justification for departing from other decisions that said significant. Similarly, open space was not to be nil. We'll come back to that in a moment for quantification. Biodiversity was to be more than limited. Economic, again, significant, started with moderate, but no reason for departing from significant. And then you have the other factors on top. Can I just go to your text? If I go to paragraph 8.1, there you helpfully set out a ready reckoner for two decisions in the appendices, or the core documents rather. I took Mr. Miller to one of those. But can we see decisions Berkeley and Oakley for market housing significant, for both affordable housing significant? I'm going to go down to economic significant for both.
Yes.
Yeah. And do you please discern a justification in this case for departing from that settled approach?
No, I reviewed both schemes and both appeal decisions. Both are within the last 12 months. The Oakley decision was in the last month. The inspectors on both occasions found significant weight to these matters. In this instance, we have a 6.25 hectare provision of public open space. The Section 106 requires a minimum requirement of 5,200 square metres. So we are significantly over the council's minimum requirement for public open space. And again, in terms of biodiversity, yes, policy EM4 does reference biodiversity, but it does not give a figure for the amount of biodiversity net gain that can be achieved on site. The environmental bill in which Mr. Miller referenced is not through Parliament yet, but that seeks 10%. And we are proposing 27% biodiversity net gain.
Thank you. And just we noted in terms of the economic benefits, to be fair to Mr. Miller, he wasn't trying to argue that it was moderate because we're 75 dwellings and Oakley was 110. But do we see the Berkeley site was 35 dwellings and that was still given significant weight for economic benefits?
Yeah, so again, when reviewing both schemes, although the Berkeley scheme is only for 34 homes, the Oakley scheme is slightly higher than ours, but in both decisions, the inspector found significant weight to the economic benefits of the scheme.
Thank you very much indeed. And then what do we then do to this list of benefits across the different topics? We know that the dimensions economic, social and environmental. What do we do for those benefits?
I think you have to look at all of the different benefits of the scheme, and it's my judgment at looking at all of them that these are significant. They outweigh any potentially localised harm that an inspector may find if that's her decision, but the benefits outweigh any material harm to the landscape.
And so what would paragraph 11D indicate?
That planning permission should be granted because it's balanced.
Thank you very much. Section 10 sets out your response to a numbered series of third-party objections from the letters of objection. We also had Mrs. Brady at the beginning of the inquiry, who I don't think we ever got her written text, but she had a series of headings that she went through for the inspector's benefit. Is there anything you would like to add to the observations that you've made, or indeed the evidence you've directed the inspector to within these points under section 10?
Yes, I will just reference a few of the points that were made by the third parties. So firstly, when it comes to education, the Hampshire County Council Education Department were consulted on the planning application, and they did seek originally financial contributions separate from SIL. However, the case officer then did remind Hampshire County Council Education that education is covered by SIL contributions, and so the legal agreement pro forma form was amended. We did meet with Mike Nichols, the business manager at the primary school, back in November 2020. He was very aware that there were plans in place to expand the school. At the moment, it is a 2-form entry school, and they will be expanding it to 2.5 form, so potentially additional 7 classes. But he was very aware of that, and it was a very positive meeting. So any education contributions will be covered through SIL. I know that the representatives also were concerned about lighting. I would draw the inspector to draft condition 23, which covers sensitive lighting. The applicant doesn't usually light their schemes. However, that will be a reserved matter detail and subject to a condition. There was also a reference to nitrates. We submitted a nitrate mitigation budget as part of the application, and it was a negative figure of 36.23 kilograms of nitrogen. And
forgive me, just that figure again.
Sorry, it was minus 36.23 kilograms of nitrogen.
Thank you.
England were consulted on the application and raised no objection, subject to a planning condition requiring 110 litres per person per day on water. So we have a no objection on Natural England grounds. Again, in terms of Sheepfair Lane, I know that the representatives have been very concerned about the safety of the road. What I would say is that as part of the application process, we agreed a scoping report with Hampshire County Council Highways to inform the transport assessment. The transport assessment fully reviewed the traffic in the area, the existing traffic flows and traffic impact, and no objection was raised to the scheme. And also Sheepfair Lane was approved under the 7-acre scheme. It's to an adoptable standard.
Thank you very much. Anything else?
I think that was the main points that they raised.
Thank you. And I say the inspector's already got the written text from the earlier recommendations. Ms. Wright, is there anything else you want to pick up at this stage?
No.
Mrs. Wright, forgive me. Thank you very much. Thank you, madam.
Thank you. Ms. Perek, are you ready for your cross-examination?
Yes, thank you, madam.
Thank you.
Good afternoon, Mrs. Wright.
Afternoon.
Okay, so just to kick off then, and just to confirm, you have been involved with this application since 2020, that's correct, isn't it?
That's correct, yes.
And I just want to confirm the documents formally submitted as part of the application. So we've got the 3 documents: the location plan, the proposed steps from Dellens, and the parameters plan.
Yes.
And just bringing up the parameters plan, I know we've all looked at this quite a few times already now, but just to confirm, the development, or rather the built development, the houses will be placed on the yellow shaded areas, and the rest of it is sort of public open space, sods, and the other sort of green infrastructure. Is that correct?
That's correct.
Yeah. And also, as you are familiar with the site, you accept that the site has a sort of sloping aspect. So the southern portion is actually the most elevated portion, and then it slopes downwards towards the northern part of the site.
Yes.
Thank you.
Sorry, would it be okay if I just put the lights on? It's gone very dark.
Yeah, absolutely.
Sorry. Thank you. I was finding it difficult to see the plans. It was getting dark.
Yeah, that's absolutely fine. And then just sort of finishing on the parameters plan while we've still got it open. I note that in your proof, you have, of course, said that this is a sort of a landscape-led design. But are you content that that's something I can pick up with Mr. Cook, or do you feel you also have expertise to add on that front?
I'm not a landscape, I do not have any landscape qualifications, but I could answer some questions and then defer to Mr. Cook.
Okay, thank you. I'll leave the landscape led design elements to Mr. Cook in that case, and move on to what you say in your proof. So turning first to the reasons for refusal at paragraph 2.3 of your proof. What you say there is that there were no technical objections from consultees, and of course that is correct, but you accept that the landscape officer did make an objection to the scheme.
Yes, we received no objection from any of the technical consultees, such as Highways or Natural England or the county ecologist, but yes, we did receive an objection from the landscape officer.
And just to confirm that the landscape officer did object on the basis of adverse impacts, both on landscape character and visual amenity.
Yes.
And again, just to confirm, this objection was not resolved. So as I understand, further comments were of course provided on behalf of your client, but that the landscape officer did not concede these points.
Yes, that's correct. However, the case officer in her committee report does assess the landscape officer's comments and does confirm that when balancing up the benefits of the scheme, her view was there was no landscape harm, and therefore she did recommend approval.
Still on your reasons for refusal then, at paragraph 2.7, you have said that the fact that the site is not allocated and the fact that it lies outside the adopted settlement policy boundary, neither of these facts effectively are cited by the council for withholding planning permission. And I think it's common ground that there's no in-principle objection to this being outside the settlement policy boundary. But just to confirm in terms of what the reasons for refusal actually say, do you accept that one of the factors that's explicitly taken into account is in fact the loss of undeveloped countryside?
Looking at the reason for refusal, it refers to the loss of an undeveloped countryside, which would impact the setting of the village, and also looking at the proposed development and whether it can integrate with the surrounding development. That was the reason cited in that reason for refusal.
Yes, so just the short point though is that the fact that you would be losing undeveloped countryside is one of the factors that led to the overall sort of reason for refusal. Yeah, and then you've addressed the reason a bit more in that answer, and so I just want to unpick that briefly. Yesterday, during Mr. Dudley's evidence, were you around for that?
Yes.
Okay, thank you. So Mr. Boyle broke down the council's reason for refusal into effectively two parts, for shorthand or convenience, and he said there's effectively the landscape harm and the visual harm, or landscape elements, character elements and visual elements. So I just want to consider what is actually covered by those two parts, and in that respect it would help if you could turn up the statement of common ground, which is CD 4.3. Thank you. And it's section 6, matters in dispute.
Yes.
I'm sorry, I'm just looking at it electronically on a different screen, so I'll be looking away from you.
That's fine.
So when we look at the topic of landscape, we've got the issues set out 2, 3, 4, 5, 6, 7, and 2, 3, 4, and 5 relate to adverse impacts, whereas 6 is about mitigation and 7 is about AO and B.
Yes.
And just to break that down further, we can see the second issue is about the impact on the setting of the village, the landscape setting of the village.
Yes.
The third issue then is that the proposal would, whether or not it would be in keeping with the local landscape character.
Yes.
And the fourth issue is whether or not the scenic quality would be materially harmed.
Yes.
And then the fifth issue is about visual impact. So just so that we're all on the same page, when we speak of landscape harm, or if we're using Mr. Boyle's sort of shorthand of landscape and visual, when we speak of landscape, it's actually broken down into these three elements of landscape setting of the village, local landscape character, and scenic quality.
Yes.
And I appreciate, obviously, that these are interlinked, but effectively, do you accept that each is a separate strand that forms part of the reason for refusal?
Yes.
And similarly, each of these three aspects would need to be assessed by the inspector.
That's correct.
Thanks. Turning then to your section 3 in your proof, and this is the site and surroundings. So I just want to pick up a few points here. At paragraph 3.4, you talk about rights of way, and very accurately say that there are no formal public rights of way within the site, and that I think is common ground. But do you accept that there are informal paths on the site that are clearly used by local residents to gain access across the site?
There's some informal paths. It would be trespassing because this is private land. It is not public open space. So if people are walking across the site, they are not using the public footpaths and therefore are actually trespassing.
Okay, I think in Mr. Cook's evidence at paragraph 2.23, I don't think you need to turn it up, but he refers to it as tolerated trespass, and he said they're informal footpaths, which he regards as tolerated trespass. Would you accept that his assessment?
Yes, I think it's been allowed to happen. So yes.
And as you will have been on site, do you accept that there are actually strong desire lines across the site which indicate where people use it to access the surrounding countryside?
I've been to the site on a number of occasions. Whether those paths change at different times of the year, I don't know. I have seen some that have worn areas within the site. So I'm not there on a daily basis to be able to confirm if people are using the same paths every single time.
Okay, and then still on that paragraph 3.4 where you talk about rights of way, you do mention the sunken lane, which is the public highway running along the northern boundary of the site. Just to check there, you don't mention the public highway running or sunken lane running alongside the western boundary, but you accept that that's also a relevant
yes.
Public highway, yes. And then similarly, when your paragraph 3.23, again, when you assess the public highways, you just mentioned the northern one, but you accept that that should have also referenced the western.
Yes.
Something like, yeah. And just sticking to this part of the proof for another moment. When you assess the surrounding area at 3.8, where you talk about bus connections, you mentioned bus route 74. And just to confirm, this is the community transport around the village. That's right, isn't it?
It is. It connects the village to the train station and also to the Bombay Sapphire Distillery.
Okay, didn't know that was in the area. Okay, I say just on that bus route 74, it's right, isn't it, that it only runs 3 half days a week?
I would need to look at the current timetable, but last time I looked at it, it was running every half an hour through the week.
I think it's covered in the statement of common ground. So if I can just refer you to that, paragraph 2.9 of the statement of common ground, which covers the bus routes. It mentions the bus route 74 runs 3 half days a week.
Okay.
So you're happy to accept that?
Yes.
Right, moving then to planning history, which is your section 4. The first point that you raised there is that this site was included in the 2020 Shalar and it had the reference OV014. Again, I think this is common ground, but as you yourself highlight in your proof, that report and the appendix that dealt with OVO 14 concluded that the development would be in conflict with the development plan. That's correct.
Yes.
Isn't it? Yes. Okay, and then I wanted on to the neighbourhood development plan process. And this is in your proof, but of course you talked about it in more detail in your evidence with Mr. Boyle as well. See, the first point, just to clarify, is that site K, i.e. this appeal site, was not in its entirety a potential reserve site in the NDP.
Sorry, you have to say.
Sorry, yeah, so I just wanted to check that in terms of site K being a reserve site, it wasn't actually the whole of the appeal site, it was just a part of site K.
Yes.
And that's demarcated in your map on page 14, where it's just the red line boundary that was put forward as a potential reserve site.
Yes.
If I can please ask you to turn up the publication version of the neighbourhood development plan, and this is reference core document 3.4.
Sorry, was it 4.4, did you say?
No, 3.4.
3.4, sorry. Yes.
And if we scroll down to page 53,
yes.
see on the top of the page, we've got risk assessment, and then towards halfway down the page, we've got the description of the reserve site, which is part of site K. And I think actually that plan there's reproduced as your map for in any event.
Yes.
And it was, so a part of this site was nominated as a reserve site in case of unforeseen and insurmountable problems with the nominated site. And it's common ground that this obviously wasn't a nominated site. And then if we just look at the risk assessment above,
yes.
The main way in which...
Could I just interject and just have the page reference in the neighbourhood plan?
I'm sorry, madam, it's page 53.
53, the version I've got on is a...
There should be, sorry, this is not the made neighbourhood plan. This is the publication version, August 2015.
Okay, all right. I'm not sure I got that, but there we...
Sorry, and it's core document reference 3.4.
Sorry, I'd opened the other one. Apologies.
Okay. So yes, so just to confirm, looking at page 53, and we've seen the part of the site K that's been reserved in case of unforeseen and insurmountable problems. And then looking at the risk assessment above, we can see how site, or rather part of site K, might come forward in terms of mitigations of risk if one of the allocated sites did not. So just looking there, it's 3, 4 on the 4th row. It says if site F is not achievable, and just checking, site F was proposed to provide 70 homes.
Okay, yes.
And it then goes to say in that scenario, what you would have instead is that you would have 70 more dwellings being provided on site J, which is where 7 acres is, and part of site K.
Yes.
So in this sort of worst case scenario, and thinking about the part of site K that was proposed, do you accept that in fact, even when it was being proposed, it was never envisaged to site 75 homes just on site K itself?
No, it wasn't, but I think it was looked at for housing, and the Overton neighbourhood plan, and also the policies, the neighbourhood plan policy says at least 150 homes in Overton, so there may have been slippages on some of the other neighbourhood sites in terms of reduced housing numbers. So I think it would have been a review at the time to see where the housing numbers were in terms of Overton.
Yes, but just in terms of this worst case scenario, the idea or what the neighbourhood plan envisaged at this stage at least was that these 70 homes would be met cumulatively via where 7 acres now is and part of Site K.
Yes, but it also says in the lower box that if Basingstoke continue increase the numbers of dwellings within the neighbourhood plan, then additional housing could be found on Site K. So there's that got to be considered as well. Yes,
I was just moving on to that. And there, that gives you no indication of what type of scale you were looking at.
No.
Okay, so then this got put forward, and as we knew, it was struck out by the inspector. And as you said, the reason that it was struck out was because, well, one of the reasons at least was there was no evidence to establish the requirement for the inclusion of this site. But if we could just pull up what the inspector actually said.
Yes,
this is
that now.
Reference core document 3.8. So core document 3.8.
Yes, I've got that. So I've got the reference to Site K.
Thank you. And that, Madam, for your benefit, is page 32 of the inspector's report. And so the inspector's looking at the Site K specific policy and in particular looking at the risk assessment table. And what the inspector concludes there is that looking at that table in terms of Site K, that it does not explain the impact of the consequences or what these are measured against. And there is no substantive evidence to demonstrate that the table contributes to the achievement of sustainable development. So do you accept that that was also part of the inspector's reasons?
It was a consideration. I think that he did look at the risks table. However, that doesn't say that the site is not sustainable or can't have development within the site. So he's just literally looking at the risks associated with the neighbourhood plan. And if you note that at the moment, 2 Gate Lane, which is an allocated neighbourhood plan site that has been refused planning permission. So that shows that there can be slippages in a neighbourhood plan and that actually reserve housing sites are important.
But this inspector took the view that there was not enough clarity of when or why Site K should come forward.
Yes, but not about the principle of development on the site.
Thank you. So just leaving that bit behind and turning then to planning policies. And I just want to go through the policies relevant to the determination of this appeal, although I'll try and take this quickly because I do actually think there's a lot of common ground between the council's evidence and your evidence on this. But just starting first with the development plan and looking at the strategic housing policies. So we start there with SD1, which sets out the presumption in favour of sustainable development, and you have given this significant weight. And then SS1, this sets out the scale and distribution of new housing. This sets out that development will be permitted within defined settlement boundaries, and that sites outside the policy settlement boundaries will be considered to lie within the countryside. And just to confirm, you've given this moderate weight.
Yes, the council cannot demonstrate a 5-year supply, so the council can't meet those housing numbers. Also, the settlement policy boundaries, which are referenced in that policy, are also out of date. So I therefore think only moderate weight can be applied to that policy.
Yes, but just unpicking that slightly, if you have accepted that SS1 in and of itself attracts moderate weight, does it not follow that the settlement policy boundaries to which it refers also continue to attract moderate weight?
Moderate weight, but they are out of date.
Yes, I think we're probably on common ground that the housing policies fall within, paragraph 11 2D. So yes, but you accept that the boundaries themselves continue to attract moderate weight.
Moderate weight, yes.
Then SS4 is about ensuring a supply of deliverable sites. Again, this is moderate weight.
Yes.
And SS5 is about supporting neighbourhood planning, identifies a need for at least 150 homes in Overton, again, moderate weight.
Yes, again, I think the word "at least" is a really important point in that. It does not set out a minimum requirement of 150 homes. And again, it does say that due to changes in the council's housing figures, this should increase the housing figures for each settlement. So that is referenced in that wording.
And turning then to SS6, this is a restrictive policy relating to new housing in the countryside. And again, you give this moderate weight.
Right.
Now, in respect of these strategic housing policies, this is just a very small point, but just to confirm, at paragraph 7.21, you mention these strategic housing policies are the most important policies for the purposes, presumably, of paragraph 11 there. And just to clarify here, do you accept that they are, in terms of the determination of this application, that they're among the most important, and that actually, for example, EM1 is also among the most important?
Yes, EM1 can be given full weight. I think these policies weren't cited in the reason for refusal, and as we've agreed, both parties aren't disputing the principle of development on the site, but are still important policies as they set the strategic development strategy for the borough.
Yes, thank you. So just then I'll move on then to these to the non-strategic housing policies, and just to establish that you do give full weight to policies EM1 and EM10. And actually you have a table on page 29, your table 7.8, and in fact you give full weight to the remainder of these policies.
Yes. Right,
then that's the local plan. Moving to the neighbourhood development plan. And before we look at the individual policies, and just as a matter of principle, I just want to establish some common ground in how we read the neighbourhood development plan. So just as a matter of principle, do you accept that the statutory presumption, that is the section 38(6) balance, that applies, the presumption, that applies to the statutory plan in its entirety? So yes. you would need to look both at local plan and any adopted neighbourhood plan.
Yes.
Yeah. And it's correct, isn't it, as a matter of law, that you need to read the constituent parts of the development plan together?
Yes, you do.
And so would you accept that, in fact, it's not necessary for the neighbourhood development plan to duplicate what is already provided in the development plan?
No, but I think the policies should be in accordance with the local plan to ensure consistency between what is being achieved in that village.
Yes, absolutely. And in fact, that's both those points are sort of that policy directive is made apparent in the NBBF as well. So paragraph 13, if I can pull up my NBBF copy. In fact, does state that neighbourhood plans should support the delivery of strategic policies contained in local plans or spatial development strategies. And so that ties in really with what we've just discussed, doesn't it?
Yes. I mean, then obviously you have to then look at paragraph 14, which is looking at whether the neighbourhood plan is over 2 years old. And in this instance, the neighbourhood plan is over 2 years old.
Yes. And just to kind of finish the point on the principle of how you read the neighbourhood development plan, you accept that it's not the role necessarily of the neighbourhood development plan to simply duplicate strategic policies that are already set out in the development, in the local plan.
It's not about duplicating, but it's making sure they're in accordance with, so that, and in accordance with the NPPF as well.
Okay, so turning then to the specific policies in this neighbourhood development plan, and I'll start with LBE1. which you set out at paragraph 7.39 of your proof. And that requires development proposals to demonstrate that they conserve or enhance the character of the landscape and built environment. Do you give this full weight?
I do.
Turning then to policy H1, and that's about residential development within existing built-up areas and on allocated sites, subject to certain caveats. And I assume this, in line with what you said about the development plan, you would give this moderate weight.
Yes, I mean, this policy refers to mainly affordable housing and the mixed dwelling types. So yes.
So that's a moderate weight to H1 then?
Yeah.
And policy H2 then, that allocates 4 sites for approximately 150 dwellings. So firstly, it's common ground that this appeal site is not allocated.
No.
And as a matter of principle, you have accepted that you can read the neighbourhood plan in the context of what is already set out in the local plan. And as we have already seen, the development plan does, the local plan does prevent development in the countryside. So do you accept that there's no need for this policy or for this neighbourhood plan to set out the same restriction again?
It doesn't have to. I mean, what I would say is that policy H2 refers to 150 dwellings, where the local plan is at least 150 dwellings. So there is slight differences in the wording between the neighbourhood plan and the local plan.
Right, but where it doesn't specifically go on to state that development would be prevented in the countryside, you accept that that principle would in any event be governed by the local plan?
Yes.
Yeah. So the fact that it's not mentioned specifically in these neighbourhood plan policies is really neither here nor there for the purposes of this appeal?
No.
And then finally, I think we just have policy H3, which asks applicants for housing to demonstrate a number of matters, including landscaping, including that landscaping responds positively to the character of the area and the other matters. And again, do you give this full weight?
Yes.
Okay. And just to finish on the policies, obviously a key material consideration is the NPPF. And do you accept in general terms that respecting landscape character and visual qualities is an important policy imperative?
It is, but then you have to read the NPPF in more detail. And again, at paragraph 174A, the site is not a valued landscape. Then looking at hierarchy of sites, it's not in a designated AONB or in a national park. So again, you have to look at the different hierarchies and weigh up that weight.
Absolutely. But I take it you don't dispute the fact that or rather, I take it that you're not suggesting that just because something's not valued landscape, that it could never be a reason for refusal.
No, but I think what you have to do is look at the mitigation as well and the site characteristics. Again, this scheme has extensive green infrastructure, 6.25 hectares of open space, and is very well screened by the existing tree belt. So I think you have to look at each site and then look at the requirements of the NPPF and its landscape designation.
Yes, absolutely. And I don't dispute that it's a site-specific or context-specific analysis. But just to confirm the matter of principle, there will rather be cases where even non-designated or non-valued landscapes could in themselves be a reason for refusal.
They may be, but they're each case on the merits.
Thank you. Right. I will turn then to benefits briefly, and you set out a number of stated benefits of the scheme in your section 8, and I just want to ask you about one of them. So this is about the open space / public access, which you deal with at paragraphs 8.16 to 8.19 of your proof. As you've acknowledged there, the site is 9.4 hectares in size, and it's currently open countryside.
Yes.
And it is currently accessed by the public, as evidenced as I say, by the desire lines, but also, as Mr. Cook says, in terms of tolerated trespass. Is that right?
Yes, they don't have a right to go onto that land. It is trespassing and it is not designated public open space.
And in exchange for the loss of this 9.4 hectares of open countryside, what we are getting instead is approximately 6.25 hectares of public open space, which will involve some tree planting and space for sudsponds in terms of proposals. That's correct, isn't it?
Yes, there's also species-rich meadows. We have the growing areas. We have new woodland, tree planting, suds features, a potential play area as well, which is in the Section 106 agreement, and it will be publicly accessible to new and existing residents in the area.
Yes, but as we've just mentioned, the site is in fact, whether in terms of tolerated trespass or otherwise, is in fact already used to access the countryside by existing residents in the area.
I would still say it's trespassing and it's not public open space, and people should not be crossing that site.
Okay, so I just quickly, if we could just turn to the recent Oakley decision, and I caveat fully that each decision will obviously need to be read in its own specific context. This is, the reference for this is, I believe, CD 5.1.
I've got it.
And in that decision, which was, I think, 110 homes, paragraph 100, the inspector considers the weight to be given to the benefit of public open space, and the inspector concludes that the development as shown in the indicative plans would provide a considerable amount of public open space. The exact purpose is yet to be defined, and the site is sandwiched between a park and a recreation ground. Therefore, only limited weight can be attributed to this benefit. So, bearing in mind that kind of analysis, which is where the site is cited, how it's, you know, the kind of what it has adjacent to it, and looking at the overall context, what do you say in your case elevates the public benefit to significant, bearing in mind the loss of what is already being used to access the countryside?
I haven't been to the Oakley site, so I've read the appeal decision, but I have not walked to the site. I have not reviewed their landscape visual impact assessment. All I can say is, again, that you keep saying that people are using that space. It's trespassing. It is not public open space, and that people should be sticking to the public rights of way. The council's minimum requirement for open space on this site is 5,000 square meters. We're providing well in excess of that with 6.25, and therefore I do think it's a significant benefit of the scheme.
Okay, turning then to decision-making processes in general, I just want to, actually, before we go on to that, I just want to flag that at your section 10, which you'll be relieved I won't go through, because obviously these do inform part of the council's case. You do mention, however, that there at 10.1 that there have been 78 letters of objection, but the committee report at least actually noted 107 objections. So I'm just, I don't know whether you're able to explain where the 78 numbers come from.
These were to the planning inspectorate, not to the council.
Oh, sorry, that's my mistake then. Thank you. Okay, so fine, turning then to the decision-making process. Now, again, this is just sort of, just to confirm how to approach these things in general terms. Do you accept that decision-making for planning is deliberately and for the large part left to the local level?
I think it's for a professional case officer to review all the documents, to review the consultation responses, the statutory consultation responses, and to make a balanced judgment. And in this case, the case officer recommended that the application should be granted consent, and it was a member's Overton, which they are entitled to do. But we did have a case officer recommendation to support the scheme, and she assessed the the benefits of the scheme versus the landscape harm, and her view was that the benefits outweighed any localised limited landscape harm.
Yes, that was the case officer's view, but as we've noted, the landscape officer had a different view of whether the harm would be localised or not. But just going back to the point about local sort of input, you do accept that the way planning decision making is structured in this country is so as to promote local democracy.
Yes, members do make the final decision.
Yes. And one example, as you've already acknowledged, is that members of planning committees are entitled to come to their own views on matters of planning judgment, as they did in this case.
Yes.
And another example is the opportunity for local residents to make their views known on proposals.
Yes, I think that's very important. And we did do extensive pre-application discussions with the council. We did meet with the school. We did meet with the surgery, the skateboard park team as well. So I think, we're very aware of the requirements and understanding of residents' views.
Thank you. And just another example of sort of local democracy having an input is, of course, through the neighbourhood development plan making process.
Yes.
And through this process, residents are, of course, entitled to assess and therefore shape and direct development in their neighbourhood. And that is, in fact, what this NDP did in identifying the 150 sites that were the sort of preferred sites that should be allocated.
Yes, but those residents also looked at the reserved site K and found that that site could take development, that they found the principle of development on that site acceptable, and it was actually the inspector that removed the site from the adopted made neighbourhood plan. But yes,
but obviously an important. Sorry, I didn't like. What was the last sentence you said?
I was just going to say is that there was a voting system on the neighbourhood plan. At different stages, the residents were asked to vote on different housing allocation sites, and site K did come out very favourably.
Absolutely, but just an important caveat on site K being put forward is that it was only a part of site K, so it's not the size
where the built development is shown in our proposed layout plan as well. So we do accord with that.
Yes, but in general terms, just going back to the neighbourhood planning process, you accept that residents are therefore entitled to oppose or to feel very strongly about what are effectively now non-allocated sites on the basis that they do not currently feature in the adopted neighbourhood development plan.
I accept that point, but they did put their site K forward for development. It was taken out of their hands to remove the reserve housing site. So throughout the whole of the Overton process of the neighbourhood plan, they were supportive of our site. So we need to bear that in mind too.
Yes, and of course, when you say site, again, just to clarify, you mean part of the site, and you don't mean this proposal, because obviously it was a proposal.
I mean as in the site K, but again, our built development does accord with site K.
Yes, but there was no proposal before them for 75 homes on that part of site K.
No.
Right, so at paragraph 9.3 of your proof, where you say that people on the whole generally adopt an adverse reaction to change and have an adverse reaction irrespective of whether it's harmful or indeed beneficial, that you have no reason to believe that that's why the residents in this case have opposed this site.
No, they have their own reasons for why they are objecting to this application, and that's set out in their letters.
Thank you. And then just the last thing I want to touch upon, so it won't be much longer, is the overall planning balance. And here, is it fair to say that where you reach conclusions on the appeal proposals according with the development plan as a whole, and that's your conclusion at paragraph 11.3, is it fair to say that you reach that conclusion by relying on Mr. Cook's evidence on landscape and visual effects?
Yes. What I would say is that I've been involved in the planning application for some time. So when I wrote the planning statement for the application, I also felt that the benefits of the scheme outweighed any localised limited landscape harm.
Yes, so ultimately your assessment though was based
Yes.
And that assessment was of, as you say, limited harm.
Yes, I think you have to balance all the benefits of the scheme against any potential harm to the landscaping. And in this instance, it's felt there's no significant harm to the landscape, and the positive benefits of the scheme outweigh any landscape harm.
And your overall planning balance, therefore, is not premised in any way on the eventuality that the inspector finds that the landscape and visual harms are in fact major and significant.
No, my view is based on the LVIA prepared as part of the application, the terra firma evidence, and also the evidence provided by Mr. Cook.
And so do you accept that if the inspector were to reject the evidence of Mr. Cook or indeed Terra Firma, then she's entitled, of course, to come to an entirely different view on the overall planning balance?
Yes, I think it would be balancing the fact that it is a non-designated site, a non-valued landscape site, the localized nature of the site, looking at the landscape, and then doing the tilted balance of looking at all the benefits of the scheme and making that decision. And that's for the inspector to make that decision.
Okay, thank you very much, Mrs. Rice. These are all my questions.
Thank you.
Thank you, Mr. Peck. There was just one point I wanted to ask you before we go to any re-examination from Mr. Boyle, and that just relates to paragraph 6.39 and 6.40 of your proof. You say, I just wanted to be clear, you say that the significant effects on habitats sites can be appropriately mitigated. Are you indicating that there is an impact on habitat sites there? Can I just be clear about what it is you mean there?
Yes, sorry. In terms of, we have to obviously look at the nitrates and the impact of the solent mitigation, solent designation areas. And because the scheme has a negative nitrogen budget, there is no harm on any designated site.
Right, okay.
And Natural England just sought a planning condition seeking 110 litres per person for water usage.
Yeah, I just wanted to be absolutely clear what you're referring to by those two paragraphs. Thank you. Mr. Boyle.
Madam, thank you. Just two matters, Ms. Wright, if I may. We came to both twice actually, but the first one, please. Do you remember it was put to you in neighbourhood plan context, the emerging site K, that it wasn't envisaged that there would be 70 houses on site K? Yeah. And that was again put to just at the very end when discussing what third parties or local residents might or might not take by way of objection at this stage. Can you just help me with this? You've already identified in your evidence that site K, which is a sort of lozenge shape within the wider application site, accords in broad terms with the area proposed for development in the parameter plan.
Yes.
Yeah. And I think you had in chief Mr. Cook's evidence. We've been to it a number of times, page 27.
Right, just find that.
Page 27.
Yes, I've got it.
And do you see there the areas shown for development?
Yes.
Under the proposal, and one can then relate that back to the site K being promoted by the Neighbourhood Planning Forum. And do you remember we looked at the land use budget, which shows the hectareage for development of 3.14 hectares. But under the next heading is density. Do you see 441?
Yes.
And that does the maths that the density, 75 dwellings at 3.14 hectares is 23.9 dwellings, which is a low density.
Yes.
You can turn it up if you need to. There is recognition of that in the statement of common ground. It's there put as 24 dph is density proposed. To what extent has the authority expressed objection by reference to density proposed in this scheme?
They haven't.
And so if we do the maths, to what extent is 75 an objectionable number to come on the lozenge shape of site K as envisaged through the neighbourhood plan process?
Yes, it would work out around 75 around 75 dwellings.
Thank you. And if the neighbourhood plan were, through its process, or indeed through our assistance, to deliver more than the minimum number specified in the SS policies, is that a good thing or a bad thing in planning terms?
I think that's a positive. You know, we desperately need housing. The government is saying build, 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 and the Overton neighbourhood plan refers to housing, and also the local plan references, I think in SS5, the minimum number of 150 homes. So, you know, providing additional homes on this site, I don't see as would be a concern.
Flip it round. We know there's no objection to the point, but were the plans to propose a profligate use of the development area K, what criticism might that lead on to?
Sorry, say that again.
Were the appellants to propose a profligate use of the area K, i.e. less than it could reasonably take in density terms, what criticism would that lead on to in national policy terms?
Yes, I think that the NPPF is clear about efficient use of land, and what you wouldn't want to do is allocate a greenfield site and then provide a lower density development. You should be ensuring that you efficiently use your greenfield sites to provide housing for residents.
Thank you very much. Second point and last, and again, it cropped up twice. Do you remember, Lanfred repeatedly put to you, there are informal paths across the site, and you repeatedly put back to her that's trespass, and they shouldn't be being used, albeit it's tolerated by the landowner. The conversion to public open space, the site is not public open space at the moment, in an area of land where there's plainly a pressure for recreational use of it and a desire to make use of it, what does that do to the weight to be given to the benefit of providing it?
Yes, I think it's a significant benefit. I was very aware when I visited at a number of occasions that there are definitely dog walkers walking, unfortunately, across the site, accessing the wider countryside. And I think the provision of publicly accessible open space that is available to the existing and new residents is a positive, and I think this gives them an opportunity to use this space for recreational purposes.
Thank you very much. And just on the maths, I think you told us in chief that the local plan requirement was 5,000 square meters for the development proposed. The context, as we've just indicated, is a pressure from existing residents already, albeit at the moment unlawfully being taken. Yeah?
Yes.
We're going to convert that to a lawful opportunity to access the countryside to those existing residents and the proposed residents. 6.25 hectares, I think, is the figure we've got.
Yes.
Compared with, is it 0.5 of a hectare, the 10,000 square meters in a hectare?
Yes.
So when the inspector's thinking about it in quantitative terms, quite apart from the qualitative and the legal issue, she goes from half a hectare, so 0 currently, half a hectare requirement to 6.25 hectares legal provision.
Yes, it's a significant area of public open space that will be beneficial to users. It will have also a play area, there'll be growing areas, new woodlands, wild, rich meadows. It will be enhancing the biodiversity. It will be a very attractive public open space for people of Overton to use, and I think it's a significant benefit to the scheme.
Thank you very much. Well, as long as we've got the quantification now established. Thank you very much indeed, Ms. Wright. Thank you. Thank you, Madam.
Thank you.
Thank you. So in terms of timings, we're happily on reasonable time to break now for lunch. Can I say we come back at 2 o'clock for the roundtable session on the housing land supply, and just to deal with the questions that I have on that subject, and then moving on to the section 106 agreement comments after that. Okay, so adjourn now and back at 2 o'clock. Thank you.
Thank you.